Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues. Please subscribe to our channel. You know, a divorce case or a custody case is like any other case in that it turns on the level of proof that you have. Some cases will be rich in proof that supports certain facts. Some will be devoid of proof because it's he said, she said. He said, she said is pretty hard for a court to judge. As a matter of fact, if you are aware that Michigan is a no-fault divorce state, you might realize that one of the reasons why the legislature turned this into a no-fault divorce state is to eliminate the he said, she said. In other words, oh, he cheated on me, he left me for this reason, she did this, she did that. I've never had a case where one person said, he abandoned us, where the other person didn't say, she threw me out. So it's he said, she said, we see it all the time. The beauty of the no-fault divorce case, it doesn't matter. You're going to get a divorce whether or not the he said, she said is there. So why it happened almost doesn't matter. So that eliminates a lot of the finger pointing and the he said, she said. But we still have other factors involved in divorce where it could become relevant, like with custody, where one person may say, I was promised that I would have the kids, all the time, and now the person's going back on it, and the first guy says, no, I never made such a promise at all. Or, we had an agreement to split this way, and we said, no, we didn't have that agreement. So the he said, she said is very difficult. The best thing you can do in the he said, she said situation is explain to your lawyer that we have to nail this down, and your lawyer will tell you, well, if we have a issue of fact based on a circumstance where one person said one thing and maybe changed their mind or who knows what, we have to take their deposition. We set out a notice, we make them appear for a sworn statement under oath, and we ask that person all the relevant questions. By doing that, we nail it down. It no longer becomes a he said, she said, because there's a record, a transcript of what they said. Now, if there's a reversal of position, you can show the court, you know what, Your Honor, this was the commitment that they made. This is what they're doing. You can see that it's not the same. They can deny it all they want, but once it's on the record, you're good to go. Without that, though, if you bring the court nothing more than an argument between two bickering people who can't agree on anything, the court is likely to throw up its hands and say, you know what, you're going to get divorced. You can either sort this out yourself, or you can write it down in your brief, and you write it down in your brief, and I'll read it and I'll make a decision. You can do that if you want, but I have to tell you, having some guy in a black robe decide what's going to happen with your furniture and your stuff and this and that, it's probably not the best way to do it, because believe me, most judges are going to find a way to make parties equally miserable. So therefore, if there's any way at all, even begrudgingly, even if you feel bad about it, if there's any way at all to resolve these issues before you throw it in the hands of the judge, you should make every effort to do so. And if your lawyer's doing a good job, your lawyer's going to push you to try and resolve things, because you never know what the ruling of the court is going to be. And you can say, well, if I don't like the ruling, I'll appeal. Great. You can do that, but then you wait many, many, many months to do the appeal. In most cases, the Court of Appeal simply affirms the decision that the lower court already made, plus you spend many, many, many thousands of dollars doing it. So, taking the full big picture into account, that might not be the best way to go. If you have questions about your case, of course, give us a call, and we'll be glad to help you out.